Welcome, and thank you everybody for coming. My name is Pope Wagner, and I'm one of the co-directors of the Center for Technology, Innovation, and Competition here at the law school. And this is our annual event going over current and emerging issues in law and technology. The idea here is to give a little bit of a preview of what's going on in law and technology over the next academic year, so that you can understand maybe before everybody else what's going on, as well as put in context the things you see in the newspapers and other places that are going on. So we have a great panel here today, and I'm looking forward to this conversation. It is co-sponsored with the Masters in Law program, and at the end of this program, at the end of the speakers, we're going to hear a little more about the Masters in Law program, and talk and answer. We can answer any questions for you there as well. Just a couple of announcements. One important one is that there's a student event coming on October 16th. CTIC has a career speaker series that we do. And we will have Teddy Jofferson here, who's the product counsel for Disney Streaming and an alum of the law school, will be here on October 16th to talk about her career and offer advice for people who might want to do the sorts of things that she's doing. So put that on your calendar. There'll be a lot more announcements about that as we go forward, obviously, but just wanted to let you know. So I'm really looking forward to this conversation. We're going to start with short-ish presentations from each of our three speakers, and then we will then move into sort of a more roundtable and question and answer session from there. And I'll jump in with some questions and comments as we go. We are recording today's event. And if you are attending virtually, if you're on Zoom and submitting for CLE credit, we'll be using polls to distribute 3 passwords throughout the event. These will pop up on your screen and will remain there for about 10 or 15 seconds. Record the passwords. You'll need those when you submit for your CLE by turning in your evaluation form after the event is over. And we will take Q&A. During the Q&A, there'll be somebody from the events team monitoring the online chat, and will pass along any conversations or questions that we get from those attending virtually to those of us in the room. All right? All right. Any questions before we go? So if not, I want to introduce our first speaker. Actually, I'm going to introduce all 3 together. So first up today, this afternoon, is Professor Gideon Parchimoski, expert in copyright law, trademarks, property, and many other topics. He's going to be talking to us about developments in copyright law. Professor Herb Hovenkamp does antitrust and IP law and law and technology. He'll be talking to us about some developments in the antitrust area. And Professor Cindy Dahl, who runs our Detkin IP clinic, is an expert in intellectual property law generally, but also patent law, trademarks, and copyright. Will be talking to us about various developments in the IP, or in the patents and trade area as well. So, without further ado, I'm going to ask Professor Parchimoski to come up and start our conversation.
Thank you so much, Paul, for the generous introduction. It's wonderful to see you all. It's a great event, and I have to say that I thought about, or considered talking about the Getty case, stability in AI, but we're still waiting for more development. So next year, I know that this is basically a promo, but hopefully a good one. And this is a big case. So in today's presentation, thank you so much, I will be talking about 3 recent cases, one of them by the Supreme Court, but I will mention a 4th case, the Warhol case. And I talked about the Warhol case last year, and I thought that, we always try to update you about recent developments, but then I thought that it would also be nice to talk about subsequent developments, effects, and hopefully we'll get a nice conversation started. So allow me to start with this Supreme Court case, Warner Chappell versus Neely, a 2024 case. And, you know, for the sake of being brief, I will skip the facts and get to the issue, and I think that that's all we need to know about this case. The issue here was, does the 3-year statute of limitations bar recovery of damages for harms that accrued more than 3 years prior to the filing of a suit? So how does it work? And in a 6-3 decision penned by Justice Elena Kagan, the Supreme Court held that under the discovery rule, a plaintiff who brings a timely infringement suit may recover all damages suffered. So for those of us who don't remember the discovery rule, and I also talk about it in property, allow me to just refresh our memory. And under the discovery rule, a claim accrues when the plaintiff discovers or with due diligence should have discovered the infringing act. And the discovery rule has been adopted by 9 circuits, and it's quite interesting because we don't really get precise instruction as to what rule should be adopted. And that was the point with which the dissent disagreed. So we also had a dissenting opinion that was authored by Justice Gorsuch and Justices Thomas and Alito joined. And the main point Justice Gorsuch made was that it's not at all clear that the discovery rule applies in the present context, and not the alternative view adopted in an earlier Supreme Court case, Petrella, under which a claim accrues when a plaintiff has a complete and present cause of action, meaning when the plaintiff can file suit and obtain relief. So what is the main message? Well, wherever the discovery rule applies, in, as I said, 9 circuits, you can recover all damages if you file in a timely fashion. What about the other circuits? Well, there we have a different rule, and the issue has not been fully resolved, and the Supreme Court did not really say whether we should work with the discovery rule or with the view adopted in Petrella. So not everything was resolved, but we do get some new information, and I think that this case is very important for copyright owners, for practitioners, so it's something we should know about. And that takes me to the case I discussed last year in the same event, Andy Warhol Foundation for the Visual Arts versus Goldsmith. And here, the issue was, cert was granted with respect to a specific question, and that question alone, the sole question presented is whether the first fair use factor, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, weigh in favor of AWF's recent commercial licensing. And just to remind you, there was a photograph here that was used. A license was given, but the license was for single use. And as you can see, several prints were made based on the license. Goldsmith sued, and this is the majority opinion. Justice Sotomayor, and this is the part that is of interest to us. If the plaintiff's and defendant's works have the same or very similar purpose, and the defendant's work is commercial, the first factor is likely to weigh against fair use, absent some other justifications for the copying. And here, the Andy Warhol Foundation licensed a print to a magazine, a use that shares substantially the same purpose as the use Goldsmith makes of her photos, and the same use for which Warhol paid Goldsmith. Okay, so the case was broadly understood to narrow down the meaning of transformativeness, and I've written about it in a separate article. Before that case, I think there was an understanding that transformativeness is broader, that it applies in more contexts, and after this case, it was clear that for a use to be transformative, it has to address the copyrighted work of the plaintiff. And here's what happened in the aftermath of this case. So these are the two updates that I have for us. The first one is called White Monkey Products LLC versus Netflix, a 10th Circuit decision from 2024. And the last chapter has not yet been written here. This dispute revolved around the main character in Tiger King. If you remember that series, I mean, if you like cats, maybe you don't want to watch it, I'm not sure. But the main character is, of course, Joe Exotic, and the dispute arose after Netflix aired a video of Exotic Joe's husband's funeral. And when sued, Netflix claimed that its use was fair. And initially, the trial court relied on Campbell, the Campbell case, Campbell versus Acuff Rose. And from that case, we distilled this broad understanding of transformativeness. So that happened prior to Warhol. And the trial court granted summary judgment to Netflix, finding its use to be fair. On appeal, in the appeal to case, took place after Warhol, the 10th Circuit reversed, and the majority, and explained that the majority in Warhol reasoned that Campbell should be understood as saying that any use that adds some new expression, meaning, or message does not mean that the use is fair. That's my point about the court in Warhol adopting a more narrow view of fair use. So the 10th Circuit found that even though the purpose of Netflix's video was different from the original work, because it viewed it as providing a historic reference on Joe Exotic and his life, the work did not focus on events in the park, so it was not enough. Furthermore, the court pointed out that Netflix's use was commercial. And as for the fourth factor, effect on actual potential markets, the court said that there was sufficient evidence of market harm, ruling that the burden of showing no market harm under the fourth factor was on the defendant. So the case was remanded. But wait, in May, the 10th Circuit vacated its earlier decision and granted an en banc rehearing that would focus, among other things, on the impact of its decision on documentary filmmaking, and oral hearings were held on July 10. So this case will clearly have an impact, as you can see, on documentary filmmaking, and we'll see how the 10th Circuit will decide it. And the second case, and my final case, is called Philpott versus Independent Journal Review. And in this case, a photographer filed an infringement suit against a news website, Independent Journal Review, IJR, after it used a copyrighted photograph of the musician Ted Nugent without permission. The photograph was used in relation to an article titled 15 Signs Your Daddy Was a Conservative. IJR argued fair use, and the court here found the use to be unfair. I'm saving you the suspense. On the first factor, the court ruled that the use was untransformative, as it depicted the musician as did the original photo, without introducing any changes, and also the use was commercial. The second factor, too, according to the court, the Fourth Circuit weighed against fair use since the original photo was artistic. The third factor also pointed against fair use because the original photo was taken in its entirety, except the fact that some of the background was cropped out, but there wasn't much in the background. And the fourth factor likewise militated against fair use, even though the photo was actually offered for free, available for free. So why against fair use? Because because according to the court, the photographer typically licenses photos to media outlets. So yes, the photograph was made available to the public, but not so to media outlets. So that's the decision. Thank you very much. I think I'm within my time limit, so this is good. There'll be time for questions, and I can turn it over to
Great.
Paul. Okay.
Yeah, her.
To her.
So we're going to hear from Professor Hogenkamp now. Briefly, let me turn. You have slides?
No, I don't have slides.
All right, let me. Do you want to turn that off?
Okay, I'm going to talk a little bit about the Biden administration's antitrust agenda and big tech, but I'll focus mainly on the Google search case because it's the only one that has gone to trial and produced a judgment at this point. The two antitrust agencies, the Department of Justice and the Federal Trade Commission, both came into being during the Biden administration with big tech in their crosshairs. And under that, each of the agencies filed major lawsuits against two of the there's basically 5 big platforms. Microsoft so far has gotten away with, there have been some merger litigation involving Microsoft, but they have not been the target of a major monopolization case, perhaps because they were the target of a case 20 years ago. But the Federal Trade Commission has sued Amazon and Facebook, Meta, but the asset that's where the violations are alleged to occur is Facebook. And the Justice Department has sued Apple and Alphabet, and there the asset is Google Search. Okay, all of the 4 cases, none of them has been dismissed. The Facebook case initially suffered a motion to dismiss, and then the Federal Trade Commission amended its complaint, and the judge sustained the second complaint, and that case is now somewhere buried in discovery, where it appears to me that by far the biggest issue is going to be market share. Who's in the market that competes with Facebook as a social networking site? The other Federal Trade Commission complaint is against Amazon. Amazon has filed a motion to dismiss, but that case has not yet received any judgment at any stage. And then the Justice Department sued Apple. Apple has filed a motion to dismiss, and the government just last week filed an answer to that motion. So that case is, I think, pretty much ready for a decision on the motion to dismiss, but we don't have that decision yet. And then the US filed 2 cases against Google. One pertained to Google Search, and one pertained to Google Ads, Google Ad sales. The Google Search case went to trial almost a year ago. The Google Ads case is just now in trial. And we have a judgment against Google, in the Google search case, and that's the one I'll be mainly talking about. I'm happy to answer questions about any of the cases if you're interested. The Google search case is the strongest of them, mostly because Google has the most clearly dominant position in that particular case. The market allegedly monopolized is what's called general consumer search. So that's a search engine, freestanding search engines, the kind you're used to probably from Google, because Google has well over 90% of the market. And its competitors are DuckDuckGo, Bing, Yahoo, Alta Vista, and then there's Yandex is a Russian firm, has very little market impact in the US. But Google is far and away the dominant search engine in the general consumer search market, with a market share running around 92%. Okay, the most serious part of the complaint, and the part that the government won on, is that Google paid boatloads of money, as much as $25 billion a year, to Apple, but to other implementers. Now, search engines are normally attached to browsers. That is, when you invoke a browser, there will be a search engine attached to it, or a default search engine, or they're sometimes attached to other kinds of freestanding programs. So, programs like, say, TurboTax may have some operations that they perform that invoke the browser on their own, and so TurboTax then would have to have some mechanism for deciding which search engine to use, and that could happen in one of two ways. One is the customer could indicate what search engine to use, but more often than not, if the search engine is invoked through an application, the application has a default search engine built into it. Now, in all of these cases, we are talking about defaults. So a default means that if to say Google search is the default search engine means that upon initial startup, so for example, when you first buy your iPhone, Google search will be pre-installed as the default search engine, which means basically, if you don't do anything, if you just get your phone working and you do a search, it's going to default to Google search. Now, you can change the default. And indeed, on the iPhone, I have an iPhone, so I know how it works the best. It's really not all that hard to change. You go in that little gearbox thing and you go to the browser, which houses the search engine, and then once you open the little browser window, there'll be a query that says select default search engine, and if you want to pick a different search engine from Google search, you can. Nobody ever does, and particularly on handhelds. Close to, not quite 100%, but 96 or so percent of handheld customers use whatever search engine comes as a default. You can also install second search engines. That's different than changing the default. So if you want to go to the App Store, for example, on your iPhone, you can download DuckDuckGo or Yahoo search, and you can pick that as a search engine. But if you just do a search through the search bar that comes on the iPhone, it will go straight to the default search engine, okay? Google, it turns out, pays a lot of money to various implementers. The biggest one is Apple, but also Android device manufacturers. Now, Google owns Android, but Android is distributed to independent device manufacturers. So if you buy an Android phone, it might be Samsung or something like that. And then Google has a licensing agreement with them, which basically, the most important thing Google does is maintains compatibility, getting a whole bunch of different manufacturers to work under a single operating system and make the phones compatible with each other. Doesn't happen automatically. So Google administers compatibility, and it also administers an app called Google Play for the sale of applications, and part of the licensing agreement attached to those Google provisions includes a requirement that Google Search be the default search engine, okay? And that was the principal and the only successful claim in the Google trial. Now, keep in mind now that what the holding is. The court did not hold that it is unlawful for a firm to select a default search engine, even if it's the market dominating one, Google. That would be a different outcome in Europe under the Digital Markets Act, which prohibits self-preferencing. If somebody picked its own search engine to be the default and was covered by the DMA, the Digital Markets Act, then that selection of Google as a default search engine, even though it was totally a unilateral act, could be illegal. But that is not what this case held. This case held that it was unlawful for Google to pay a whole bunch of money, and the sums were really very large, to implementers like Apple, so that Apple made Google the default search engine on, it's on both iPhones and on iPads. And so that payment was the thing that was declared unlawful, okay? That went to trial. There was a lot of testimony from experts, including first ever the government's major use of behavioral economists. Now, if you know anything about economics, you know that most economics as taught today is neoclassical, and all economics and antitrust, practically all, is neoclassical. Behavioral economics is a little bit different because it looks particularly at limitations in how the human mind works and how those responses might be different from the purely profit maximizing responses that neoclassical economics would pick. So a human being might select a particular search engine, or stick with, that was the most important question, stick with a particular search engine, even if it was not the optimal choice under behavioral economics. And the judge paid quite a bit of attention to that. So I think one of the major implications of the Google search case, remember this case has only gone through the district court. It is subject to an appeal to the DC Circuit and of course potentially cert review as well. But the district court, now Judge Maida, an extremely good federal judge, moderate and very, very sharp, very factually focused. But he gave credit to the testimony of the behavioral economists that there were impediments that inhibited people from switching away from Google search, even though they might have preferred a different search engine. Okay, so the one thing that comes out of the case is that the payment of money to make Google search the default search engine is illegal. Okay, now this is a monopolization case, so that leads to the question then, so what was the source of Google search's dominant market share, 90+%? And there the record was ambiguous. I mean, first of all, there's pages and pages of testimony, much of which Judge Maida described in his almost 300-page opinion about Google's superiority as a search engine. Google has put a lot of resources into working out its search engine. It's fast, it's efficient, they spend a lot of time trying to match search results with what they think user preferences are. And so the quality of Google search is very, very good. On the other hand, the payment for the defaults was clearly an inducement to customers who received a device with Google search installed as a default, not to switch way to a different search engine. And very significantly, Judge Maida did not resolve that question. Now, the posture of the case right now is that there's going to be a second trial, second hearing next summer in which the parties will litigate the remedy, and at that point, promised by August or so, Judge Maida will issue a second remedies decision. There, the options are, the weakest and most obvious option is an injunction against the payments of money, so that each device maker, like Apple, would have to select on its own which it wants to be as a default search engine, or put in what's called a choice screen. The EU already has a choice screen for Android devices. That would mean simply there'd be one additional screen in your startup menu, and when you get to that screen, there'd be a list of search engines, and you would pick a default search engine. That's another possibility. The government and numerous third parties, including mainly Microsoft owns Bing, which is the second biggest search engine, but Bing only has about a 6% market share. They all object that this horse has already left the barn. Google already has a 90% plus market share. We know that the quality of a search engine is heavily driven by the size of the database, and that gives Google such an enormous advantage that simply stopping the payments at this stage would mean pretty much that everybody would go right ahead and pick Google search anyway. So the parties are likely, the plaintiff-aligned parties, including the government, are likely to ask for something more than that injunction. What would that be? Well, hard to say. One possibility is a divestiture, something like forcing Google to spin off, forcing Alphabet to spin off Google Search. That's not really a very effective remedy because it doesn't break up the monopoly, it only sells the monopoly to a different owner. It would still be a monopoly. Nevertheless, it's one of the things that's, excuse me, that's being debated. Now, how much time do I have?
You can go another 5 or 10 minutes if you want.
Yeah, you got.
I can go 10, but I might go 5. Another thing which the court refused to do, however, is force Google to share an important asset that it uses in the sale of online advertising. The current name of the asset is SA360, Search Ads 360. It actually evolved out of an earlier company called DoubleClick that Google acquired 10 or so years ago. And it's basically a digital tool that enables buyers to post ads on multiple websites and even operating systems at the same time. And it's a big marketing advantage. And Microsoft wanted access to SA360 so it could use it for ad sales on its Bing search engine. Google refused to do that, and the government held that refusal to license out SA360 was an antitrust violation, but Judge Maida disagreed. And he followed there a long line of precedent in U.S. antitrust law that even a dominant firm has no duty to share assets with its rivals. And I think Judge Maida is dead right on that. If something is going to happen there, it's going to be because the Supreme Court changes its Trinco decision that overrules a decision from almost 20 years ago, holding that a dominant firm does not have a duty to share its assets for rivals. That holding, I believe, bodes poorly for the government's complaint against Apple, because the Apple complaint is all about Apple's refusal to Apple's refusal to share various features that have been developed on the iPhone with competitors, and really the only serious competitor is various versions of Android phones. But for one is iMessage, where if you're on an iPhone, you get iMessage and you get a little blue screen. If you're on an Android, you get standard SMS messaging, which is claimed to be inferior. Another one is superior support for electronic watches. Numerous companies make digital watches that sync with the iPhone, but the Apple Watch, one of which I have right here, syncs a lot more stuff. It syncs better and but most importantly, it syncs more than if you buy a Fitbit or some other third-party electronic watch. Apple's cloud services for uploading your photos or other large quantities of data to the cloud are claimed to be superior to Android's cloud services. And finally, Apple refuses to permit what in the business are called super apps. A super app is simply an app that is capable of selling other apps. And this has become an issue in the Apple case, because the only way you can upgrade things like if you want to buy game levels, this has already been litigated in a case involving Epic Games. If you have an Epic game that you play on your iPhone and you want to buy additional levels, you can only buy those levels through the App Store, and Apple takes a sizable commission on every single sale excuse me, that's made through the App Store. So these third parties, they want to permit what they call side loading, or basically use of a different app, so that you might put an Epic Games app, for example, on your iPhone, and you would be able to buy higher levels of games directly through the Epic Games app, and you could bypass the App Store. That, by the way, is more like the system that's already in existence for, say, Windows desktops and laptops. Microsoft does not get a chunk of every piece of software you buy when you buy something through your Windows machine. You can buy software, say, off Amazon or Egghead or some other website, and the transaction goes straight through that website, not through some bottleneck that Microsoft has created. The problem is those are all features or improvements that Apple has created, and in the US at least, the rule is pretty sharp, pretty strong, that a firm that develops superior technology or superior products does not have a duty to share or license those products to its rivals. And so I think that decision on the part of Judge Mehta in the Google case is probably pretty immune from reversal. And I also think it bodes poorly for the Apple case. Now, like I say, the Supreme Court could overrule Trinko and hold that there are broader duties on the part of dominant firms to share their good stuff with rivals. I don't think it's going to be this Supreme Court that does that, however. Now, if Kamala Harris, I'll give you a scenario. Kamala Harris gets elected, Alito and Thomas both retire, and she puts 2 Democrats on the court. We might see a broader duty to deal emerge from the Supreme Court, but we're not anywhere close to that yet. Thank you.
Now we'll hear from Professor Cindy Dahl. Do you have slides or?
I don't.
Okay, perfect.
So what I'm learning is that the FTC has been pretty busy lately. And this is actually a good segue, Herb's discussion. Herb's discussion about what the FTC has been up to in the antitrust realm is related to what I'm going to be talking about. I've been doing a lot of thinking lately about the FTC's ban on non-competes, and the reason that that is important in my area of the law is as an IP generalist, I see a lot of tech companies, and I do think a lot about trade secrets, and the FTC's ban on non-competes impacts my clients and in tech in general. So what happened? So the FTC engaged in some rulemaking started in January of 2023 when they proposed a ban on non-compete clauses. Now, what are non-compete clauses? Non-compete clauses are contractual clauses or entire agreements that basically keep an employee bound to not work after they leave one employer for a competitor of that employer. And at base, what they're trying to do is they're trying to control an employee from taking secret information or information that the first employer finds valuable, confidential, to an employer, to a competitor, to another employer. So that's non-compete agreements. So the FTC basically banned enforcement of non-compete clauses and agreements. Basically said we no longer, companies can no longer cause their employees to sign non-compete agreements and cannot even enforce the past agreements that they had already had their employees sign. There were just a few carve-outs to this. Basically, they said that folks that were so-called senior executives that made just over $150,000 in the past year, those non-compete agreements that they had signed could still be enforced. And there was a little carve-out for when a non-compete is part of the sale of the company. But by and large, what they said was non-compete agreements no longer valid for what had already been signed, and companies could no longer force their employees to sign those non-competes going forward. So this was the proposed rulemaking in January 2023, and they opened it up for public comment. They got 26,000 comments. 25,000 comments, they reported, were in support of the ban. So they held a vote. It was a close vote, and they finalized the rulemaking in April of 2024, and the ban on non-competes was set to go into effect on September the 4th, just a couple of weeks ago. Well, as you can imagine, non-compete agreements are pretty normal in the United States. There are only 3 states that before the FTC national ban basically had declared non-competes prohibited. So companies were madly using non-compete agreements to control the flow of their data. And as you can imagine, as data becomes more important in our economy, we were relying a lot as counselors of technology companies on non-compete agreements. So the clapback was quick and pretty fierce. There were 3 suits that were almost immediately filed. At this point, that ban has been enjoined nationally. The FTC says that they're going to continue the fight, but they haven't yet appealed the ban. I'm going to talk about what happened in those court cases. So the first case was in Texas, and it involved an accounting company. It was called Ryan LLC versus the FTC. So the first thing up was a preliminary injunction. Because remember, this was supposed to go into effect in September. So they moved quickly, and in early July of 2024, that district court in Texas granted the preliminary injunction. There were 2 other cases I'm going to talk about in a second that were also bubbling in other districts. But in the meantime, the Ryan case actually moved pretty quickly, and they ruled on the merits in August of 2024. And this now has resulted in this nationwide set-aside of the ban. Basically, they said 2 things. They said that the FTC exceeded its authority by prescribing this nationwide ban. They had based their rulemaking on Section 5 of the FTC Act. specifically the FTC's authority to regulate unfair methods of competition. Because they were basically saying that this was an overreach of companies and they were affecting competition. But in reviewing and interpreting the FTC Act, the court concluded that the FTC lacked statutory authority to make substantive rules. They said that they were limited to only make procedural rules that would guide agency organization, procedure, or practice. So they basically said the FTC had greatly exceeded its authority. They also said that the ban was what they called arbitrary and capricious. They said there were other ways basically to stop this anti-competitive behavior or this unfair methods of competition. And the FTC hadn't adequately discussed or considered any other ways. So basically saying by not considering sufficiently some alternatives, this was a one-size-fit-all approach and it was sort of a draconian knockout of non-compete agreements. So thus, we had an injunction stopping the ban, if you're following. So non-competes now are still kind of okay, but the FTC right now is definitely fighting them. So meanwhile, there were different results in two other cases, one right down the street in the Eastern District of Pennsylvania. In each of the cases, in those other two cases, the court signaled that the FTC actually did have the authority to make such a substantive rule, but in this particular case, they didn't do it correctly. So, and that was just a signal. So what happened in those cases? The one down the street is ATS Tree Services LLC versus FTC, and in that case, they did not grant the preliminary injunction, so they allowed the ban on non-competes to proceed. They said basically the plaintiff couldn't show irreparable harm, which it needed to be able to show, and that it was unlikely to succeed on the merits. Why unlikely to succeed on the merits? They said the FTC is empowered to make substantive rules, so they didn't do anything wrong here, and then they rejected all of the other alternative arguments, including an argument on major questions doctrine and an argument that the FTC was going into the province of state law. So basically, the preliminary injunction in Pennsylvania was denied. Third case, Properties of the Villages versus FTC in the Middle District of Florida in Ocala. You've heard of the Villages for a lot of other reasons, I think, as well. So also in this case. In that case, they did grant the preliminary injunction, but they said it wasn't because the FTC had no authority to make those substantive rules. They granted the preliminary injunction based on the fact that in this particular case, the FTC exceeded its authorization because it presents a major question. It's getting back to the effect of basically banning an instrument that many companies use in very broad ways across the nation. And so could the FTC actually ban it entirely? Maybe this was actually a major question that should be legislated rather than come out of the agency. Neither of the latter two courts has indicated if they're going to rule on the merits. So right now we are stuck with what happened in Texas. So until it is appealed, this is where we are. Of course, behind these cases, if it is appealed in Texas and goes up to the Fifth Circuit, or even if it does go up to the Supreme Court, which some people are starting to think at some point it might, we've also got Loper-Bright to think about. Loper-Bright was a case in administrative law over the summer that basically said that if an agency is interpreting a statute that is ambiguous, that the agency's interpretation should be given deference. Because of Loper-Bright, the FTC's ban on non-competes will not be given the same deference that it might have been given a year ago, if it does come up on appeal. So all of this is sort of in the ether, and I've been thinking a lot about what this means for how we counsel clients in the clinic and outside the clinic that have trade secrets. Because we used to rely pretty handily on non-competes and non-disclosure agreements. And I should say that non-disclosure agreements are also swept in under this FTC ban to the extent that it is operating in a way that keeps a person from going to another employment. Non-disclosure agreements are different from non-competes in that they follow the information, basically contractually binds an employee from sharing certain information. Whether or not they go to a competitor or not, they're not allowed to share the information. And so, of course, if they go to a competitor and they share the information, that can be in violation of both a non-compete and a non-disclosure agreement. But we use both. The reason that we use both is because under trade secret law, you have to prove that you have taken reasonable measures to keep whatever you're claiming is a trade secret, secret. And there are lots of ways that you can take reasonable measures to keep something secret, but very easy ways to do this is through contracting. You don't have the contracts to rely on, then you have to rely on technological resources or lockdowns. You have to have corporate policies. Of course, you would have all of these things, but it also really helps to have those contracts that you can point to and say, we have everybody sign a contract that says the information cannot be shared. And so when you remove the non-competes, then that does change how you can prove easily that you've taken reasonable measures to keep your trade secrets secrets. So I've been thinking what this means for trade secret law. In some of the comments about the FTC ban, Lena Khan, the commissioner of the FTC, said, you know, it's no problem to get rid of the non-competes because we have trade secret law. So I've been thinking about whether or not trade secret law is a full substitute for non-compete agreements. And I don't think that it completely is, for two reasons. The first reason is that it's easier, potentially, it's different to allege breach of contract than to allege misappropriation of trade secret. It's potentially easier to prove that there is a breach of contract. Did somebody go to a competitor or did they not go to a competitor? It's a little bit more black and white than did they have access to the secrets? Did they take them? Did they download them? There's a lot more sort of forensics that have to be done potentially to see if there was misappropriation, which is the claim under trade secret law. So it's a little bit more black and white if you have the non-compete agreements. Trade secret law is a little bit harder to prove. It's more expensive potentially to prove. And so I don't think that they are necessarily complete substitutes for each other. Of course, from the company's point of view, they would like to prevent that trade secret misappropriation at all. And so if you have contracts, it's much more proactive about letting people know what the consequences are, what they claim, you know, is the confidential information. So when you're proving trade secret misappropriation, you know, to Herb's point, the horse is out of the barn. You're trying to show there has been damage and you're trying to contain it. But everyone knows that if trade secrets have been disclosed, it really undermines your ability to protect those trade secrets going forward. And so contracts are different in that they are proactive and they're also clearer. I understand all the arguments about non-competes keeping folks from moving from place to place. And I understand that it impacts certain folks more than others and that we may have been using them rather broadly. But I've been thinking a little bit about whether or not the FTC ban on all non-competes at all times for all people going forward is necessarily, you know, the way to go, or if it is a little bit arbitrary and if we should be thinking about some alternatives. So just tee up a couple of questions to talk about.
Yeah, great, thanks so much. All right. So now I'm gonna ask each of the panelists a couple of questions and hopefully start a little bit of a conversation among the four of us, and then we'll take some questions from the audience. So first for Gideon, I mean the program here is sort of what's happening over the next year, right? So, you know, lots of predictions came out right after the Warhol case, right? That fair use was going to be fundamentally different and potentially dramatically narrower. I think, you know, we're seeing a little bit of concern out there with respect to sort of the news gathering industries or documentary films, as you noted. What is, given your sense of what's going on out there, what's going to happen over the next 12 months or so in the fair use area?
So it's a great question, and I'm very happy you asked it. Although, wow, what do I know about what's going to happen over the next 12 months in the world? But I will try to answer your question. So I'm so thankful, Paul, because I've been writing about it. It's very difficult to assess the effect of a decision just by looking at the case law, and that goes back to the article. It's co-authored with Roy Baharad, and the idea is this. So the scope of fair use also affects bargaining between rights holders and users. And if we have a very broad definition of transformativeness, as users, you can always approach the copyright owner and tell it, look, I mean, there's a real chance that our contemplated use will be considered transformative. So okay, we can litigate it, or, and that also goes back to your presentation, and that's something that we should consider, like what will happen. Or, let's just think about a fair license that you would give me, and I will not go to court, I will not argue fair use. Now, when we narrow down fair use, my bargaining leverage as a user gets weaker, and I think that was part of the Warhol decision. Now, do we see this full effect in court cases? No, it will be very interesting to see what will happen with the cases that I mentioned, with some additional cases, but maybe already behind the scenes, because reported cases are just the tip of the iceberg in our world. A lot is going on. It's just hard to know. If we had a transactional lawyer in our midst, we have one. So we should probably get some expertly views on this, but I think it will have an effect. I don't know that always commentators tend to exaggerate. This is the end of the world, the end of fair use. I don't think so. And again, I think that it's a reasonable decision, Warhol. It's not so extreme, if you ask.
Right. Interesting.
Thank you.
I'm wondering if we could open up the discussion to the elephant in the room, the AI cases and fair use, right? Because we just had a ruling, right? Was it Internet Archive? The Internet Archive case about how that wasn't transformative because all they were doing, this is the library case, right? Where
It's just archive.
they basically they had I think they got 6 million books through like legitimate means, and then they scanned them all in, and then they basically were competing with the ebook market because they were allowing people, and then they said no fair use.
Right. As I said, when I started my presentation, I'm waiting for what I consider the big cases on generative AI, and the fair use claims there are very, very strong. And I honestly do not know what will happen with our artistic communities in the future. So we're looking at that case, but the genie is out of the bottle, and very difficult to compete with AI, as I think many of us will learn soon. It's coming. And if I'm allowed to follow up on your question and ask, or when we define markets, do we consider AI? So you said the search market, and I have to say that I learned so much from your talk. My iPhone came with a Russian search engine, and it doesn't have any of the fabulous apps, so I'm beginning to suspect that something is amiss with my phone. Could it be?
On the street.
Well, to answer your question, the given wisdom, and I think it's essentially correct, is that the reason market share is so lopsided in consumer search is because product differentiation is so difficult to maintain. We got lots of platform markets, social networking sites, dating sites, magazines, where you've got platforms, but you have dozens or even hundreds of competitors, but not consumer search. And the fact is that search engines have not been very successful at differentiating their products. And right now, there's a serious debate going on about whether AI may change that. AI may give search engines the tools to vary their search results, tailor them towards specific customers, and we would get a market that looks a little bit more like the social networking market, in which people pick a search engine based on a set of features that are tailored to their own life experiences, profession, and whatever. We haven't gotten there yet, but that's at least part of the debate. But under the current regime, everybody pretty much agrees that sustainable multi-firm competition in search is very fragile, because everybody's going to congregate to the biggest search engine simply because quality is purely a consequence of the size of the database.
So Herb, another question for you. One of the observations that I've heard many make about the recent platform-based antitrust actions brought by the government has been a real different or even missing theory of consumer harm, right? In a lot of these cases, you either see very little conversation. It's very focused on the behaviors of the firms and a lot less on how this is affecting, at the end of the day, the consumers, right? So, dovetailing on what you just noted, it sounds like it's probably better for consumers if we all just use the Google search engine. And absent some sort of evidence that they were using dominance to leverage themselves into other markets or something, we would, probably consider that socially good. Apple, right? Like, maybe the fact that they are spending enormous amounts of resources to develop, features and tools that can only be used on their platform, at the end of the day, provides consumers, additional features and tools, as well as product differentiation from their competitors. Is there something that's changing fundamentally about the way that we think about antitrust concerns?
No, I don't think there is. I think the Biden administration's targeting of big tech in the way it has been a mistake. It violates the usual rules of law enforcement triage, which is that you put your assets where the problems arise. So what do you do? If you're in drug enforcement, you go to the borders, the airports, and so on. You don't go to the country clubs so much. If you're in antitrust, you look for industries that are highly concentrated, where there are very low rates of innovation, a lot of collusion or attempts at collusion, lack of new entry. Big tech doesn't qualify in any of these. It remains the fastest growing portion of the economy. Economic growth in tech is roughly 3.5 times bigger than that of the economy overall. New entry into tech is very, very fast. Employees are well paid, well educated. Consumers are very satisfied. Prices are very low. In fact, one of the most common prices in big tech is zero. So it doesn't really fit the model of places where you want to put your antitrust resources. And for the same reason, it doesn't provide the same obvious benefits. Now, there's another antitrust area that the Biden administration has gotten involved in, and that's worker pay. I think that's a totally legitimate use of antitrust. Worker wages have been falling behind growth. We say what we call the worker share of participation in economic growth has been falling. We can produce real and visible results with more aggressive enforcement in behalf of labor, and those visible results would show up as higher wages, more employee mobility if they want to have it, and so on. The RealComp case involving landlords, the P&B case that was just filed yesterday, I think, involving pharmacy benefits managers. Those are cases where you will quickly be able to see improvements as a result of a remedy. Right now, people are kind of scratching their head and looking at Google search and saying, what kind of remedy can we come up with that's going to benefit, that's going to make search better? Or, you know, it's easy to break stuff up. Federal courts have the power to do that. It's easy to give handouts to smaller rivals. They have the power to do that too. But if your target is making a product that is better for consumers, either because the quality is better or because it has lower costs or so on, coming up with a remedy in a case like Google search is not an easy thing.
On that issue, and a very quick follow-up. So apropos behavioral economics, is the solution of sticky defaults, is it being discussed at all? So for
It was discussed
it was
very
discussed,
heavily.
yeah, okay.
I mean, one of the big issues.
Yeah, because I got used to my Russian search engine, and in fact, I
Well,
even learned
defaults
Russian.
are much stickier on handhelds than they are on desktops. I mean, I'll give you an example. You get Google search as your default search engine on your iPhone. Well over 90% of customers stick with it. On the other hand, any Windows product, desktop or laptop, comes with Bing as the default search engine. Well over 65 to 70% of people who buy Windows machines default away from Bing to Google search. So it's easier, and there's two explanations for that. One is that escaping from the default is a whole lot easier on a bigger device, which is factually probably true. And then there's Google's explanation, which is everybody defaults to Google search because we have the best search engine. You know, you can take your pick of those answers, but there's no question that defaults are sticky.
So let's move a little bit to Cindy's talk. I agree with you that it does seem like trade secret law is unlikely to be a very satisfying substitute for the way that non-competes are currently being used. On the other hand, do you agree to some extent with the FTC that in particular non-competes at sort of these lower skill jobs that are not in the $150,000 annual pay range, you know, that typically don't involve high degrees of information transfer, that non-competes in that context really, one, probably are harmful, and two, really don't need to be substituted with anything at all?
Yes, because I would imagine that there is a class of employee that probably is not being exposed to the most valuable trade secrets of a company. Or I could see that there could be many people that are not exposed. At the same time, I think basically taking all non-competes out of the equation, I have to think that I know they thought this through, but I have to think that there has to be some other middle ground.
Yeah.
And it injects a lot of ambiguity into our non-disclosure agreements as well, because they basically say non-disclosure agreements that act like non-compete agreements, but I don't know what that means.
Right.
And so trying to translate that into
Yeah.
what do you tell the person across the table about their tried and true contract? Do you have to redo this? You know, or is it okay?
Yeah. And so what do you do, just as a, you know, as a practical matter, if you're a firm now that has probably signed, you know, 15, 20 years of non-competes, right? You've got thousands of employees potentially, all of whom probably signed when they joined the firm a standard agreement that had some non-compete, or maybe non-disclosure components to it, you know, what types of advice are practicing lawyers, you know, giving that right now? Obviously, the FTC rule's on hold, but of course that you know, temporary TRO could be lifted at any point, and the Biden administration is obviously not done yet, right?
Right. So they were telling their clients, law firms were telling their clients, get those notices ready, because the part of the FTC ban was that when all of the past non-competes are no longer enforceable, the employer was actually also required to tell all of the employees that had signed a non-compete that, oh, we're not going to enforce it against you. And they had to tell that to them in writing. So they had to be able to prove that they had done this, that there was effective notice. So law firms were telling their clients, get those notices ready. Potentially, let's look at your language and scale it back. But completely serendipitously, 2 hours before this panel, my son, who works for a hedge fund in New York, called me and he said, hey mom, you know, he just got a promotion. I have to run this agreement by you. It has some non-compete language in it, and I'm really kind of, I don't know if I should sign it or not. I'm like, well, clearly, all the companies out there are still doing this, and yeah.
Yeah.
So what did you tell them though?
We're talking tonight.
Because I'm against non-compete, and I actually think that, you know, some middle ground invites litigation. Employees don't have the wherewithal to litigate, and so it's not going to work. The only thing I can think about is a very strong default that is cannot be easily modified. The assumption would be that non-competes are invalid in my world, in that category that Paul described, and it will be upon the employer to show why a specific non-compete should be honored, because I get a feeling that there are real negative externalities for the economy, for individual autonomy. You know, I don't want to work there anymore, but you're forcing me, and I can't find a job.
But trade secrets not ideal either, right? I mean,
Not
you
ideal,
imagine
but-
firms spending a lot more money trying to lock up, to compartmentalize, to litigate
Sure.
over a trade secret. I mean, that isn't an ideal world either.
I have reservations about that too, and I'm thinking about an article that would create a public domain for trade secrets, but, you know, not enough time for one project.
The straw that broke the camel's back here was widespread migration of non-competes into things like fast food franchising, where these people work, you know, they make $8 or $10 an hour chopping head lettuce, and suddenly they have non-competes.
No.
They do.
McDonald's.
They have to sign those contracts. What leverage do they have?
I didn't realize that.
You know, Jimmy John's has litigated, McDonald's has litigated, and probably some others.
So what are the trade secrets that those low level?
There's always something you can claim.
Just right.
No, I know.
Yeah, how to slow down
Sauce.
service, for example.
All right, so one more quick question of each of our panelists, and this is just pure predictive. So I'll start with Cindy. So one way or another, in January, we're going to have a new presidential administration. How is the law for each potential administration? How do you think that the law in the area in which you're most interested could potentially be affected?
I would imagine that were we to have Kamala Harris be our next president, I think that the FTC would probably get another whack at this. And I think, honestly, what I think is happening is I believe that the FTC aimed really high to get this out in the ether, and then is gonna have to, through the courts, it's all gonna sort of sort out a little bit. I think we probably swung too far into a direction of McDonald's employees signing non-competes. And so I think that this is going to get the national discussion back into something that's a little bit more reasonable. But I think that they're gonna keep pushing. in order to basically get something changed about what we do about non-competes.
Okay,
At least in big tech, I think under either a Harris administration or a Trump administration, antitrust will move to the right. I think they're gonna lay off of big tech. In the case of Harris, a couple of reasons. First of all, she's got pretty strong roots in California and Silicon Valley. But secondly, her message has been very consumer-oriented. Low prices, higher output, things like that. That fits well with other parts of the antitrust agenda, but it's hard to rationalize that story with the attack on big tech. So I expect some lightening up on big tech. Trump is a wild card, although, you know, the best evidence we've got of what Trump would do is what he did in his first term, which was he picked a pretty strong conservative, Mikan De La Reme, as head of the antitrust division, who was pretty much non-enforcement. And I think that went more across the board, both on big tech, on mergers, and on so on. So I think no matter what happens, we're going to see a little bit less aggressiveness in antitrust after the inauguration.
Gideon, any predictions?
Yeah,
And-
so I don't think there'll be some profound effects. I think that Herb summarized it for me as well. It's the composition of the Supreme Court that matters a lot. But there could also be a message that's in keeping with what Cindy just said. So if Harris is president, you know, the message would be businesses not to overreach, whereas if Trump is elected, there'll be a sense that, you know, we're all for property rights and more protection. But I don't know that copyright law will be affected in a deep sense, the same way that, you know, non-competes in big tech, for sure, the platforms will be affected.
Okay, all right, we have about 10 minutes left, so.
I have to add that I'm wrong more than 50% of the time.
So if there are questions from the audience for any of our panelists or for multiple of the panelists, so we'll start over here. Go ahead.
Question for Professor Overkamp. So on the Google search, we talked about the user side of the market, but not the advertiser side. So how do you weigh the interests of users versus on the free side versus advertisers on the paid side?
So far, the government has not done a very good job of dealing with two-sided markets. What they've tended to do is use traditional market share criteria, looking at only one side. They did it in the Facebook case, they did it in Amazon, I'm talking about their complaints, and also in the Google search case. So they're basically counting numbers of users, not advertisers. And that makes a real difference when you're computing market share because, for example, Google search accounts for something like 92 or so % of consumer usage, but only around 35% of advertising revenue. Okay, well, normally we measure market shares according to where the money comes from. So why don't we say Google search has a 35% market share? And the answer is that the demand is generated by the consumers. And that is not a good solution, I don't believe. On the other hand, it's kind of hard to come up with a better one. Market share is just not a very reliable way of measuring power on two-sided markets, and particularly not when you've got different market shares on the two sides, and that happens all the time.
Okay.
Other thoughts, other questions? And please speak up as loud as you can. There are good mics, but we do have people in the audience.
With respect to fair use, the Goldstein case could be read, I think, I'd suggest, as simply saying that the days of simply invoking the phrase and the concept of transformativeness as almost a proxy for a fair use analysis are gone, and that there are other statutory factors that have been in there since 1976. You have to look at them. And so in that case, they looked at the fact that whatever degree of transformation happened because of changing the colors and stuff, it wasn't all that much, and it wasn't enough to outweigh that it was used for a substitute purpose, a commercial one at that. And that's where the problem lies. In those days of just saying transformation is fair use are over.
I completely agree, by the way, and I said it's a reasonable decision, and I was nodding as you were asking your question. I do agree with that. I thought that the Second Circuit went too far by saying, changing meaning. We can't do that, and then artists will never be able to get anything from licensing. And look, I think academics, as Paul mentioned, we're all over that case, but I'm actually with you. I think that the line is drawn at a very reasonable place right now, because if we are looking at what the meaning is, and that's transformativeness, and anything is transformativeness, you just add some colors and you're Andy Warhol, you're a famous artist, and you just touched it, and that's transformative, then,
It's certainly the assertion in the Kat Von D tattoo case, where she took a photograph of Miles Davis and with incredible accuracy, put him on skin as a tattoo, and said that that very act was transformative.
Yeah.
And of course, Goldstein happened, and that
Yeah.
didn't work
So
for
I-
Kat Von D very
I agree. I think it's a fair decision, and one that
I mean, the
draws the line.
concern though, under that view of Goldstein is in the area of, say, documentaries and newsmaking, right? Where you do often have to use pretty much exactly the same image in pretty much exactly the same way, but you're doing so for quite a different reason, right? Which is newsworthiness or commentary, criticism. And I think a lot of people have concerns that the Warhol case was not sort of sufficiently, didn't know that was going to be one of the overhanging
But
effects.
Warhol didn't present those facts.
It didn't. And so then the question is, how are we going to sort of reconcile the Warhol sort of understanding with the cases like the Joe Exotic case, where that's clearly, they're trying to make some sort of newsworthiness argument, and the courts originally just said, no, that doesn't work anymore. That can't be true, right? And we're going to have to figure out how that plays out, right?
So just one more sentence. In terms of going back to basics, we still need to go back to the Wendy Gordon article from 1982. And for documentary filmmakers, they really face serious transaction costs, and that's something that must enter the equation. But that's not what happened in the Warhol case. I mean, she agreed to license the work. We know that. So why should fair use be granted and then the artist doesn't make any money? It's a different situation for me, if you ask me.
My question's for Professor Dahl. I'm curious to know, in terms of your predictions from what you've seen, either in the clinic or just in terms of what you've read, in terms of how in the patent world, firms and universities are thinking about patent strategy as it relates to goods or services that are either generated entirely by AI or with the use of AI. For example, Synthemol and Stanford's University campus, if they were to commercialize that, what would be sort of a firm strategy take on how to go about commercializing it if it's not patentable?
So what would a university do if a lab came up with a invention that was made by AI and they wanted to protect it?
Yeah, exactly, because that's what Stanford said.
Interesting.
Because the PTO says that's not patentable.
yeah.
What they say?
Because
You
it's
said
not
that?
patentable.
But it's,
Not
So,
No patent.
yeah, just in terms of like the USPTO guidance that, there has to be significant human contribution.
so what would they do? How would they protect it?
Yeah.
Well, so I guess you've got trade secret. And if it is not, well, I know that question is still going through the process. I guess my first answer for you is I don't know, and I haven't seen it yet. But the university is pretty bullish about protecting their inventions. I think that they would try to cobble together some kind of a way to do it. And I think that just because it's a university doesn't really change what happens. It could be any company that is coming up with an invention through AI that they would like to protect, that we can't protect yet through patent or may never be able to protect through patent. So I think you have to lock it down through contract. You have to basically think about it as a trade secret, and then we wait and see what happens in the courts. But
So it would mean that fewer inventions would be subject to disclosure early on.
the downside
Yeah.
would be that it would discourage probably quite heavily the disclosure of inventions.
Right, yeah, yeah.
All right, we have time for one more, and then,
Online?
are there online? No, all right, go ahead.
This is for Professor Hovenkamp. When you were earlier talking about tech and why that might not be the main focus that the government should be looking at earlier, you said there were some factors that you would look at for why certain industries might be particularly important to scrutinize. In the case of Facebook or Meta, I know that one line of argument that some people make is that in acquiring Instagram and maybe further consolidating social media, that led to a company that would be too big to need to worry about certain security measures, or also the adverse effects that it had on like teenage mental health or younger. And I'm wondering, when you think about consumers, it's usually in the prices traditional sense, or at least that's what some people, I was taught in undergrad economics. But I'm wondering how you weigh those types of adverse effects to consumers when you're thinking about, should the government be focusing its resources on this type of behavior?
Well, I tell you what we actually do, and it may not be a fully satisfactory answer to your question, and that is we treat mergers differently than we treat internal growth. So the preferred remedy in a merger case is a divestiture or a breakup. And right now, the Facebook case has basically been reduced to 2 mergers, Instagram and WhatsApp. And that would be a totally conventional use of merger law, abetted by the fact, I should add, that Zuckerberg has not merged either one of them into the primary network. They're not part of Facebook. They're separate networks with separate membership. They do share some data, but they still are separate networks. And those kinds of divestitures are fairly routine in all industries, and pretty easy to justify. Now, price is still a problem, right? Instagram is also free, so you're not going to get any improvement in welfare from that. Whether you get improvement because Instagram is now able to go head-to-head with Facebook, I don't know, I doubt it. There's actually quite a few players in that market already. But it certainly would not be as robust as it would be in the case of a positive price market.
All right, so we are at the end of our time. I'd like to ask Kathy Restrepo, the director of our Master in Law program here at the law school, to speak for just a couple minutes, 1 minute or so, on the Master program.
Yes, thank you so much. I would say maybe 30 seconds or so to cover 3 things. First, introduce the program. Second, express gratitude. And third, perhaps most importantly, depending on your appetite, is to extend an invitation to a reception outside and perhaps inside at the clock. I think the wind may...
You have 5 more minutes, sure.
Yeah. But as Professor Wagner mentioned, Catherine Restrepo, the Assistant Dean of the Master in Law program, I realize I don't need to introduce the program to many because I see a number of our faculty and I see a number of our students in the program. So forgive me for those of you who are familiar, and for those of you who aren't, perhaps just a moment and then share with others. If you're not able to stay for the reception, you can certainly reach out to us online, but we'll be at the reception to answer more specific questions for anybody who has that. The program was launched just over 10 years ago. In fact, one of our primary faculty in the program helping us design and build the program was Professor Wagner himself. And the idea behind the Master in Law program was and continues to be to provide an education or access to legal education for professionals and students preparing to enter professions outside of the law, and for whom an understanding of the law of their fields, or perhaps even more generally, an understanding of the law would benefit their careers, would enable innovation, and provide societal benefits in general. We do that through 3 pathways. There's a master's degree. There is a certificate. The master's degree requires 8 courses, and the certificate requires the completion of 4 courses. And then we offer an opportunity, depending on your status in the university as student or staff, we offer an opportunity for individuals to join us for classes. And some of the classes for this audience, as you might imagine, we heard about today, right? trademarks, copyright, antitrust, unfair trade practices, patent law, and a number of those courses are offered through the Master in Law program and through the JD curriculum. So let us see, and that, as I said, I can answer some more specific questions when we're out at and my colleague Tula, whose chair is empty, she's outside getting the reception ready for all of you. But if you have any more questions, we're happy to answer those. And anybody who's online hearing this, or if you're not able to stay, certainly reach out to us by email, and we'll be happy to make arrangements. So secondly, I mentioned I wanted to express gratitude both for our panel. It's amazing, really very interesting. I look forward to it every year. It's the best way to earn CLEs, I think you'll all agree. Also to our CTIC colleagues and particularly Caroline Olson and our conferences and events colleagues for enabling us to partner with you. We're happy to first broaden the audience to give you access to this amazing, interesting intellectual content, but also for enabling us to get in front of a larger group to share news of the program. And then I think lastly, my third goal is to invite you all to the reception. So hopefully you can stay, join us. We're right outside in the courtyard and downstairs in the clock. Thank you so much again. Oh, that was my thanks to the audience. Thanks to all of you for joining us.